On 23 January 2023, the Commission sent you a request for the submission of the 5-year Declaration of Assets and Personal Interests. And on 30 January 2023, you submitted your 5-year declaration. The Commission also asked all candidates to voluntarily complete and submit an ethics questionnaire, and you did so on 5 July last year, 2022. The Commission sent you 3 rounds of questions on 19 April, 29 April, and 11 May 2023, respectively. You were asked a total number of 23 questions, including 73 subparts, and 37 of the questions included a request for further documentation. According to Article 3, Paragraph 4 of the evaluation rules of the Commission, a candidate may not provide information, documents, or other materials during the hearing if the Commission requested these earlier and the candidate did not provide them within the time specified, unless, of course, the candidate provides sufficient justification therefore. Members of the Commission will now start with asking you questions, and Victoria Henley will start with asking questions first. We will try to keep our questions short and to the point, and we ask that your answers be short and to the point as well. Victoria, you have the floor.
Thank you. The first question I will be asking you about has to do with a $300,000 lay guarantee of a loan obligation. And I'll briefly describe the facts and then ask you some questions. On 12 August 2019, you signed a contract of guarantee with a microfinancing company. According to the provisions of the contract, you became guarantor for a loan of $300,000 lei, due in 60 months at an annual interest rate of 20%. The loan was contracted by a third person, who I'll refer to as just IC. You pledged all of your assets jointly with the debtor for the obligation assumed by the debtor, namely the loan of $300,000 lei. In response to written questions from the Commission, you stated that you were friends with IC and that you accepted to be her guarantor so that she could get the loan. According to a copy of the certificate issued by the microfinancing company, you stopped being the guarantor for this loan on 24 January 2022. Law 133/2016 on Declaration of Assets and Personal Interests requires the subject of the declaration at Article 4, Paragraph 1, Subpart E, to disclose personal debts of the subject of the declaration in the form of numerous assets, guarantees, if their value exceeds the value of 10 average salaries in the economy. According to government decision number 678/2019, the average monthly salaries per economy in 2019 was 6,975 lei, and in 2020 was 7,953 lei. Thus, debts in excess of 69,750 lei were required to be disclosed for 2019, and debts in excess of 79,530 lei were to be disclosed for 2020. You did not declare this guarantee obligation in your annual declarations on income and personal assets submitted to the National Integrity Authority for 2019 and 2020. And now I'll ask you some questions. On 12 August 2019, you became a guarantor for a loan of 300,000 lei, contracted for 60 months with an annual interest rate of 20%. Is that correct?
Yes, it's true.
Okay. And the credit was due back in 2024, yet you ceased being a guarantor on 24 January 2022. Did the debtor pay back the full amount of the loan before the due date?
No, the debtor did not fully reimburse that loan. It's still valid. No, actually the contract with the guarantor was terminated with me because I didn't want to further act in this quality.
Okay. And why did you stop being a guarantor before the due date?
Somehow the manner in which the debitor was paying this loan stirred some doubts, and I decided to stop acting like a trustee, like a guarantor for the bank, because I was responsible in the same manner as the debitor for that amount. And the way in which she used to pay back the debt, the amounts, stirred some doubts in me. That is why I gave up to that. And the bank accepted.
So the bank just permitted you to withdraw as guarantor?
Yes, the bank allowed me. And it is confirmed. I got a certificate from the bank about this.
Okay. And you explained in answers to questions from the Commission that IC, the person who had taken out the loan, was a friend of yours, correct?
That's correct. It is a female friend of mine, and during the time period when I gave up to act further as a guarantor, she left abroad, and this was one more reason which drew me to the decision to give up to the status of guarantor.
Okay. And your relationship with IC was that she was a friend of yours?
Yes, it was friendship.
Okay. As you agreed to guarantee the obligation assumed by her, I assume you knew the source of funds available to her to pay back the loan, correct?
Yes, I confirm.
Okay, and could you explain what those sources were? Was she employed, for example, or what sources of income did she have?
Yes, she was providing services as hairdresser. She was a hairdresser, manicure, so in this area, like in a beauty salon.
And how did you know that she would be able to pay back the loan?
Well, she claimed having revenues. So she was holder of the beauty salon, but she did not present any acts to me. So more specifically, she did not prove anything to me, but she presented this to the bank, and the bank accepted to offer this loan to her, provided that there are two contracts for guaranteeing. It wasn't only me as a guarantor. There was a second guarantor. Maybe it is still acting as a guarantor. I don't know the name. Since I was in good relationships with that person, I accepted to be helpful because she needed this.
Okay. And do you know what the purpose of the loan was?
No, I don't know.
Okay. And do you know how the loan was used?
Something vaguely, she subsequently told me. She had some more debts and she would use this to refinance the other debts.
And so the reason that she needed to borrow funds was in order to pay off other obligations.
Yes, right. This is what I understood from her words.
Okay. And do you agree that according to the law you were obliged to declare the guarantor obligation in your declaration submitted to NIA for 2019 and 2020?
Da, desigur că sunt de acord.
Yes, certainly, yes, I agree with that. And this situation, at that point, I even didn't think about this. Well, it popped up when the Commission asked me about this guaranteeing. And then when I checked attentively in the declaration and then double-checked with the law, it is then that I understood that I was supposed to declare that. But I did not declare because at that point, when I was completing the declaration for 2019-2020, it just went out of my mind. Well, as long as it didn't bother me at that point, I declared what I was owing. But since those were not my money, I even didn't think of doing this. But now I agree, I was supposed to declare.
Okay, and you weren't aware of the obligation to disclose the guarantor obligation?
Și știați?
Contacted about the commission, by the commission, correct?
Nu.
No.
I'm now moving on to a slightly different subject. In 2019, a different aspect of it, in 2019, you contracted several loans from banks and financial institutions. I think in the handout we've given you, we list them. 300,000 lei on January 30th, 7,000 roughly lei in March, 10,000 lei on 2 April, 90,000 lei on 13 June, 579,000 lei on 13 June, 20,000 lei again on 13 June, 8,600 lei roughly on 27 June, 52,370 lei on 9 September, and 20,000 lei on 24 October. In response to questions from the Commission, you explained that some of these loans were contracted for purchasing and renovating the apartment that you purchased in 2019, for personal expenses and for refinancing. The two biggest loans, which are numbers 4 and 5 on that list, were contracted from banks and were secured by a mortgage on your apartment. Now some questions. Do you confirm that in 2019 you contracted the loans that I've listed?
Da, confirm.
Yes, I confirm.
Okay. And do you confirm that when you signed the contract of guarantee on the loan taken by IC in August of 2019, that you had two existing loans at the same microfinancing company, namely the two loans listed as Loan 3 and Loan 6 on the list?
Da, confirm.
Yes, I confirm.
Okay. As of August 2019, you already had a mortgage on your real estate for the loans contracted by you that are listed as loans number 4 and 5. Is that correct?
Da, corect.
Yes, it's correct.
Okay. Could you explain how you considered it possible to guarantee a 300,000 lei loan for a third person?
Deci, înainte de a semna un contract de fită.
Before signing the guaranteeing agreement, the bank verifies the status of this candidate. And since the bank accepted me as a guarantor, and I was asked by my friend, I knew my friend really needed this money. Sometimes I also required somebody to help me at a point in time, so I decided to accept. And I admit that was a risk on my side, but I decided to help.
And when you were contracted the loans that you contracted in 2019, were you required to fill in declarations that included a disclosure of liabilities that you had?
I cannot really remember right now, but I submitted all the documents as the bank requested. So possibly this was also there, but I cannot remember exactly.
So do you recall what the banks required you to disclose in terms of any existing liabilities when you applied for loans in 2019?
Da.
Yes.
Da.
Yes.
Descrierii, da.
Yes, they were asking about my liabilities, debts.
Instituția care
And there is even an institution which checks the credit history of the applicant. So all my liabilities, credits, loans, obviously they were registered. It's actually by the bank. The bank did this double checks in the database versus my personal loans. Debts.
So you disclosed your liabilities when you took out loans, and the bank then also did their own check?
Da.
Okay.
Yes.
And do you recall when you signed the contract of guarantee with the microfinancing company for the credit of 300,000 lei? Were you required to fill in a similar declaration as far as assets and liabilities that you had at that time?
Nu mi-aduc aminte la moment.
I do not remember right now.
Nu pot să vă zic.
I cannot say.
Dacă
But
este o regulă, înseamnă că
if there is such a rule, then it happened like this. But I cannot say I remember exactly whether I filled in something like this in any declaration.
Okay. And do you recall whether there was an application, though, that you had to, or some kind of documentation that you had to fill out as far as agreeing to be the guarantor?
nu, absolut.
No, absolutely. I don't recall anything.
So you don't recall whether you had to disclose existing debts when you undertook to be the guarantor for the loan for IC?
Probabil că da. Eu
Probably yes, but I cannot remember right now.
intuiesc că trebuia
But
să
my
se
guess
ceară
is that yes, they were supposed to ask me do this. And this is about my credit history. But I most definitely declared this if it was requested because I had nothing to hide.
Okay. And do you know if when you filled out whatever documentation may have been required for the guarantee obligation, whether you disclosed the mortgage of your apartment and your existing debts?
Eu am declarat despre creditul imobiliar.
I declared about the real estate loan, the loan for the real estate.
Este angajat
So it somehow entails the fact that the apartment was mortgaged because the loan I got, it was a loan for real estate.
When you became the guarantor of the loan for IC, if IC in theory was not able to pay back the loan, how would you have fulfilled your obligation to pay back the 300,000 loan?
Cred că greu.
It would be hard.
Eu cum am menționat și mai devreme.
Well, as I mentioned earlier, it's true that was a risk taken by me. But I did that step. Now,
Cum avea să nu pot să zic ce avea.
how I would be able to pay back this, I'm not sure. But frankly to say, I never had any issue, so in the long run that person paid her installments. But as she left abroad, as I said, that was one of the reasons. We didn't have the same relationships as before.
And of the 300,000 lei loan to IC, did you receive any portion of that loan?
Absolut nimic.
Absolutely nothing.
Okay, I have no further questions.
Is there anyone else from the colleagues who has a question on this particular issue?
Thank you.
If not, then Vitaly, please go ahead with the next issue.
Vă spun și eu bună ziua. Doresc să discutăm despre un subiect care anterior
I suggest we could stick to a different topic,
care anterior a fost deja abordat.
which was previously tackled in a communication with the Commission. It's about the car. So I will describe the facts and then I will address a couple of questions to you. On 12 August 2017, you were empowered by notarial power of attorney to possess, use, transfer ownership of a vehicle, model Toyota Aygo 2007. In your 2017 annual declaration, you declared this vehicle indicating rights of possession and use. You listed the value of the property as 0 Moldovan lei. You submitted to the Commission a copy of the sale purchase agreement for this car, dated July 17, 2018, which involves you as both the buyer and also as a representative of the seller. Citizen SS, I will use the initials, SS. The contract indicates the value of the car as 8,000 lei. In your response to written questions from the Commission, you stated that the car was purchased from the car market in Chișinău and you have absolutely no relationship with the seller. Like she was an absolutely stranger to you who simply sold her car. In your declaration submitted to NIA for 2018, 2019, 2020, you did not indicate that you were the owner of the car. Instead, you declared again that you had the rights of possession and use, and declaring the value of the property as 0 lei. Only when you submitted your annual declaration to NIA for 2021 that you finally declared that you were the owner of the car and declared the value of the car as 60,000 lei. In written communication with the Commission, you explained that you paid 60,000 Moldovan lei for the car. You explained that the price was listed in the contract as 8,000 lei at the seller's request. In response to a question about the purpose of a loan of 100,000 lei contracted from a commercial bank in 2017, you stated that 100,000 Moldovan lei loan was meant to cover the purchase of the car. Today's market value of a similar car varies between 2,300 400 euro, like 44,000 to 76,000 Moldovan lei. I hope I described the factual side in full manner and a couple of questions. And I hope you will be able to just provide short answers like yes or no. And you will have the opportunity also to provide clarifications to the aspects. Please confirm that on August 12, 2017, you were empowered by notarial power of attorney to possess, use, transfer, ownership of car model Toyota Aygo, year 207. Yes, I confirm. Please confirm that you provided to the Commission the sale purchase agreement for this car, dated 17 July 2018. Was this the date that you actually purchased the car? Well, de facto, I bought the car in 2017 when I went to the car market, when I bought it. But it was only done like a power of attorney, which would allow me to possess and use it. And it would allow me the right to subsequently do all the paperwork. Upon the expiry of the power of attorney, it is then when we did the contract in 2018. Yes, but de facto the car was bought in 2017. Then another question. In your declarations submitted to NIA for 2018, 19, 2020, you did not declare that you were the owner of the car. Instead, you indicated that you had only rights of possession and use. Is this correct? It is correct. I declared like this. But that was rather a mechanic mistake, because in 2017, when I purchased this vehicle, based on the power of attorney, that's what I indicated. And subsequently, in the following years, the data were just copy-pasted. I wasn't attentive about this rubric where I should involve the ownership right. As I remember correctly, in 2019, I further rectified this information.
I wanted to ask you a similar question about the price, because it was indicated with a 0 as well, and I wanted to ask you, because you said in the first situation was like a mechanic mistake that you made, but then in 2017, 2020, you continued to indicate it with a value of 0. I said that I did that because I did not have the obligation at that time to declare value of the asset as well, the value of the car that is. But then when this obligation emerged, I indicated the value of the asset too in 2019. Now, if this car was purchased in 2017, while you were aware of the provisions of the law that set out that it was supposed to be declared, but then since you didn't do it, then I would like to ask you what was the reason, why you did not, why wasn't this car reported or declared as the law requires? But I already explained that I declared for 2 years the right of use only. That is what you're asking me about, right? I said it is just that at that time when I'm filling in the declaration, when you're supposed to do that, some data is carried forward from previous declarations, and I didn't pay enough attention to this particular aspect that I was supposed to indicate the right of ownership, not the right of use. So the information was forwarded from the 2017 declaration onwards, and at that time I had declared only the right of use. I just did not correct that particular information. It was my inadvertent omission. In the declaration to NIA for 2021 and thereafter, you indicated that the value of the car was 60,000 lei. Is that correct? Yes. In the copy of the sale and purchase agreement that you submitted to the Commission, the indicated price was 8,000 lei, correct? Yes. Do you confirm that in your written explanations submitted to the Commission, you explained that you indicated a price of 8,000 lei in the contract because that's what the seller's request was? I confirm. You explained that that person was a stranger to you and that you didn't have any type of relationship with that person except for the particular sale and purchase of the car. Is that correct? Yes. Do you confirm that in the sale and purchase agreement that was submitted to the Commission, you appeared as both the buyer and the seller? Yes, I confirm, because the action was carried out on the basis of a power of attorney issued by the seller. Now, considering the other previous answers that you provided in writing, and now again you said that the 8,000 lei appeared in the sale and purchase agreement because the seller insisted that you do so. So considering the circumstances that you were both, well, the buyer and the seller, representative of the buyer and of the seller, practically, since you represented the seller, why did you accept to indicate the incorrect value in the agreement? That's what the seller asked me, and I just complied with it. I perhaps shouldn't have acted like that, shouldn't have done that, but it was something that the seller asked me. He asked me to put down that amount. Everybody used to do it like this back in that day. But just to be certain that we are on the same train of thought. So you paid that seller the money in 2017. Yes, that is correct. And, well, in fact, you paid for that car. I certainly paid. I paid 60,000 lei. So at the market, I gave that money for the car. And to sort of make things simpler, because we were supposed to do all the paperwork, so we went to a notary and we just got that power of attorney. But the money was given in 2017 at the market. I gave the money to the seller. Now, although it's clear from the circumstances of the case, I would like to ask, because there is the possibility to have a power of attorney and represent the seller and for the seller to be present. Was the seller present when the agreement was concluded? No. And you decided to indicate 8,000 lei because in 2017, yes, that is correct. I mean, I was asked to do it like that, and I didn't want to make it make a situation out of it. Please confirm that you took a loan of 100,000 from a commercial bank in 2017 to buy this car. I confirm. And this fact happened 8 days before the date of the power of authority that was given to you to possess, use, and sell the car, correct? Yes. You answered this question, but just to be certain that I got it right, 60,000 lei was the amount that you paid to the seller when he had this power of attorney made. And when? So speaking in terms of the time, when did this happen? On the 12th of August, if I'm not mistaken, in 2017. If the power of attorney was in 2017 and the money was paid, so what was the problem? Did you say that it happened all at the car market? I know what the realities are. Actually, there at the market, there are a few notaries adjacent to it who are ready to perform all these works for the contracts, and it can be either a power of attorney or a contract. I don't see the difference. But now my question is, given that back in 2017 you paid the money for this car and a power of attorney was drafted and then allowed you to buy it from that seller, then why was it necessary? Why didn't you just on that day have a sale and purchase agreement drafted and then just be done with it? I don't even know why we did it like that, why things happened like that. That's how we agreed that it would be faster, it would take less time, and there was the judgment back then, and that's the answer. All the more so since I've had some consultations with other people. Many people used to do it like that, so I didn't even wonder about it, and I never even thought that there should be any doubt about whether it should be a power of attorney or a sale and purchase agreement. So at that time, I didn't even wonder about it. And now, another question. Now, considering your answers, you are a declarant and you are supposed to properly declare the assets that you've acquired. In 2017, you actually purchased a car for a particular price. You did not have a sale and purchase agreement, but the ownership right was already established, but then you did not declare that car for a number of years. But you knew that you've already bought it and the money was paid. What was the problem with declaring it as required value and all that, and having a contract in place? That's where we have some questions. We see when the date of ownership emerged, and then still you nevertheless kept not declaring it properly. When in 2017 I declared this car, I declared it in line with the documents that I had. I had the documents that allowed me to use it and possess it, and that's what I wrote in the declarations. I couldn't have declared the ownership right as long as I didn't have a sale and purchase agreement. But then later I explained that for 2 years I did not declare this the right of ownership because it was a mistake on my side not to do it. But then I fixed it in 2019 when I made the required adjustments and I indicated the price and the sale and purchase agreement and the ownership right that I had over that car. Is there anything you would like to add to clarify about this matter? Nothing.
Victoria, back to you. Yeah.
Right, and if I could just ask to clarify, I believe that it was our understanding that the declaration submitted to NIA for 2018, 2017, 18, 19, and 20, you didn't indicate that you were the owner of the car. You continued to indicate a right of use and declared the value of the property as zero. Is it your understanding that in 2019, you declared that you were the owner of the car?
Yes, in 2019, I declared that I was the owner of the car for the 2019 declaration.
Okay, I have no further questions.
else having any questions on this? Vitali, you can go on with the next one. Yeah.
Another issue that you are aware of, because we've addressed it during our communication before the hearing. You were married from 2011 to 2017. Your then husband did not register any type of income between 2007 and 2015. You were asked by the Commission about the income and expense imbalances over 2011-2015, in which you had negative balances ranging from 7,000 to 26,500 lei, for a total difference of about 110,000 lei. In your answers, you confirmed the amounts of your salary as well as the loan-related expenses. You stated that your husband at that time received income without an official contract, working in construction. When asked about the income of your husband between 2011 and 2015, you did not provide the amounts of income or the number of days worked. But you told the Commission that you didn't know and you told the Commission that you didn't know anything about the work of your husband. You informed the Commission that you were not in a good relationship with your husband, and from what he told you that he worked sometimes as a day laborer in constructions, but that he and in repairs work, but he never told you specifically how many days he worked or when. You also did not declare any income for your husband in the declarations that you filed on income and personal assets. So at that time, the declarations were being submitted to the National Integrity Commission, and that we refer to the years 2011-2015. You told the Commission that you did not declare your husband's income because he never told you what his income was. The Law 1264 from 2002 on the declaration and control of the income and ownership by various officials, including prosecutors, in Article 4, paragraph 1, letter A, requires the subject of declaration, the declarant that is, to declare income obtained together with family members during the declaration period. And now I will follow the same pattern and ask you a couple of questions. So please confirm that in the written questions of the Commission, you were presented with calculations of your income expenses for 5 consecutive years from 2011 to 2015. Yes, I confirm. According to those calculations, in those years, you kept having a negative balance varying between 7,000 to 26,000 lei, for a total difference of about 110,000 lei. You are aware of this information? Yes, I am. Can you confirm this? I confirm. In the written communication with you, you agreed with the calculation provided by the Commission regarding your salary and the loan-related expenses. So you agreed with that information, yes. You also explained that other sources to cover the expenses were some minimum income from the former husband, A.S., who's been working periodically as a day laborer in construction. Is that correct? Correct. The Commission asked you to provide supporting documentation for any other sources of income that you've identified, that you referred to, but you did not provide any documents, records, or declarations to support your husband's income from construction work. Is that correct? Yes. You were asked to provide an estimate of the income of your husband. You, however, did not provide that either, correct? No, I did not. Do you agree that the provisions of the law, of the aforementioned law, 1264 of 2002, requires the declarant to declare income obtained together with family members during the declaration period? Yes, I agree. Can you confirm that in your annual declaration submitted to the CNI for 2011, 12, 13, 14, and 15, you did not list any type of income earned by your husband? No, I did not declare. The circumstances of the case shows that, well, it appears that you knew that your husband was generating some income, earning some income previously in that period, and you confirmed that the law indeed required you to declare that income. Why didn't you declare your husband's income as the law required, and that for 5 years in a row.
Deci nu am declarat.
I did not declare,
Și am explicat și
and
comisia
I
știe
explained
despre
the
asta.
commission, and I'm willing to do it now again, that my relationship with my husband was not good. He never wanted to tell me what his income was. I was aware, I knew that he was a day laborer, but that was occasional and not constant, as in he wouldn't work every day or every week. But occasionally, when somebody would ask him to help out with work, then he would go and work there. He never really brought home income in the form of money, but he would buy foodstuffs for the family, he would buy clothes for the child, and that only if he would afford it. I did not declare it because I didn't know. I totally was unaware. I never knew precisely what income he had. I would realize very well that his income was really minimal. And considering that I didn't know anything for certain, and he would even refuse to be specific, I decided to rather not declare anything at all, rather than introduce incorrect information in the declarations. I do not want to keep pushing you, but now still I would like to ask a general question to maybe try to understand how this situation happened. I understand this is a private matter, your former husband, but we would like you to have I look at it like a case that we could be talking about. We looked into your income and expenses over a particular period of time. We noticed that at a certain moment in time, we can see constantly negative balances. And we asked you whether you agreed with the income and expenses that the Commission calculated, and you said that you agreed with that. About the negative balances, you provided a number of answers, and you said that in that period of time, there was no negative balance because it was set off by the income of your husband at that time. And you said that you were aware of the fact that all income, all amounts earned as income should have been declared. And when we asked you to provide an estimate, a rough estimate of the income of the husband, because you said there was some income, you said that you were not able to provide because you didn't know and you couldn't answer. So this is something that we're trying to understand. If there was this income that he was earning and setting off that negative balance, there should have been some sort of calculation as to how much he contributed. Well, as I previously communicated, he wouldn't bring money to me at home for me to make calculations and figure out what his income was. So all his contribution to the maintenance of the family was, well, he was providing for the family by buying foodstuffs and clothes for the child. Where was he taking the foodstuffs? How would he pay for that? I don't know. I really don't know about it. And now I cannot say anything about it. I cannot just say a particular amount that he could have earned in a day, a month, or a year. I've never known the specifics of it. That's why I couldn't tell anything to the Commission. And the last question. So you can't figure out how much money he was spending, but nevertheless, you were certain that his income was setting off the negative balance, because if not, then that can shed a different light on your income and expenses. Well, what was setting off, or this compensation, so to speak, it was not only him. My mother, who was still alive at the time, she would help me out as well. She worked, she was employed, but what is certain is that the expenses that I had regarding the loan-related expenses, and other expenses, I would cover that with my own salary. As for other expenses that I had, such as food or clothing, or, as I said, my mother also helped me, and he would also sometimes bring something home. I accept your answer.
Anyone else from the colleagues wanted to? Okay. Shall we go next to the next one? Back to Victoria. Go ahead.
I'm next going to ask you about transfers totaling 197,000 lei, roughly. In other words, 12,000 euros from Russia between 2013 and 2014. During the period of 2013 and 2014, your then husband, initials AS, received 8 transfers from Russia totaling approximately 11,500 euros. The transfers were in 2 different currencies, some in euros and others in rubles. The transfers came from 3 different people in Russia. In regard to the transfers to your then husband, you told the Commission that he received the transfers from a former college colleague, whose initials are AC, from AC's brother VV and the brother's concubine OC. Or, sorry, the brother's, I believe, VC. VV, okay. You told the Commission that you did not know about these transfers and that these people are complete strangers to you. You asked your former husband about the transfers, and he advised you that the money was never intended for him. You indicated that he explained to you that he received these transfers at the request of AV to transmit them to the parents of the brothers, inhabitants of the Gloden district, who were elderly and unwell and did not have the opportunity to receive a transfer. You also wrote that the 3 persons who made the transfers are not available by phone and they cannot be found on social networks. And I think we've included in the materials for you today a list of the transfers that includes the dates of the transfers, the amounts, who the recipient was, and the initials for the senders. Can you confirm that between 2013 and 2014, your then husband received 8 transfers from Russia with a total value of approximately 11,500 euros?
So I cannot confirm it because I was not aware of these transfers. I only found out about them when the questions came from the Commission. So it's again that situation that my former husband was quite specific a person. He had these peculiarities. So at that time, back in 2013, 2014, as it is said out there, I was never told by him about these transfers. And it's thanks to the Commission that I found out what my husband was engaged in, involved in. When the Commission asked me questions about these transfers, although we no longer keep in touch, I don't keep in touch with my former husband anymore, really. I nevertheless called him and I asked him about these transfers, and he told me, he confirmed that he indeed received that money because his former college colleague asked him so that this can be further transferred on to their parents. At that time, certainly, I was upset at him, and I told him that I was supposed to have reported these transfers. But then he told me that he didn't tell me anything because this money was not meant for us, and so it was not ours. That's why he didn't tell me about it. So if these transfers are there, they exist, I can't confirm that they existed and not. But he did though confirm that these transfers happened.
I understand. As far as the information that we have and the amounts, do you have any reason to dispute the accuracy of that information?
I can't question anything because I wasn't aware. I didn't know. I don't know how much money was transferred. I believe it should be the way it is set out in the documents because there are documents that confirm that such money was transferred.
Okay. And these transfers were sent by 3 different people, correct?
Correct. Yes.
And in your written communication with the Commission, you explained that the senders were a former college colleague of your then husband, which you just mentioned, and that person's brother and that brother's concubine, correct?
Yes, I said that on the basis of what my former husband told me.
Right, and you stated that your husband told you that he received the money in his account in order to transmit them to the parents of the 2 brothers because the parents were elderly and sick, correct?
Correct. Yes.
And the district where the parents lived was Gloden, correct?
Așa mi-a spus.
That's what I was told.
Okay. And that's located about 128 kilometers distance from the city where you and your husband were living at the time, correct?
Corect.
Okay.
Yes.
And you stated that you didn't know about the transfers that your husband received and passed on to the elderly parents, correct?
Nu, absolut nu am cunoscut.
I had no idea about it. I did not know about it.
Okay. And on the table that we furnished, it indicates that the 11,500 euros was received in 8 different transfers. And some were on different days in the same months, and others were months apart. Does that appear correct, at least what's on the table?
Probabil că sunt corect pe baza tabelelor.
I guess, yes, if I look at the table, then it turns out it's like that.
Din moment ce eu n-am
Since
cunoscut,
I
nu pot să zic
wasn't
că dacă
aware of
este
it,
marcat
but if
tabelul,
that's what the table says, I do not question it.
Okay, and in your written answers to the commission, you stated that your then husband was only a courier to go to AV's parents in the Gloden district to transmit the amounts of money that had been transferred at the request of AV, correct?
Corect.
Yes.
And when you stated that he was a courier, you meant that he delivered the funds to the parents, is that correct?
Da, corect. Da.
Yes. Yes, he would receive that. He would pick up the transfer and then he would either send it, or I don't know how he would do it, but then that money he would make sure that the money would get to those parents.
Okay, and you just mentioned that he might transfer. I mean, do you have any idea how he got the money to the parents?
Nu am. Probabil intuiesc
I don't know. I think that maybe he was traveling on his own, because otherwise, what would have been the point to transfer them in a different way? I guess he was traveling there on his own to take that money to those people. I don't know what was the method that he used to make sure that the money arrived at the parents.
Okay, well, I think previously it was said that the parents weren't able to receive transfers, so I think...
Așa mi-a comunicat cel puțin.
That's what I was told, because the parents were ill and they didn't feel well. Perhaps maybe they had some other issues as well. I don't know. I was just told that the parents couldn't get transfers. So for that reason, he was the one to pick up the transfers.
Okay. And neither you or your husband owned a car at that time. Any idea how your husband would make these deliveries?
Nu cunosc.
I don't know.
Nu, chiar nu cunosc.
I don't know. I really don't know how he would get that money there. Maybe he would ask somebody to take him there. I don't know what he was doing to get the money there. I didn't ask about it. If I was asked this question, then maybe I would have asked him about it, but I did not ask him about this, about how he would make sure that the money would get at those people.
And your husband had to travel, if he delivered them from your residence to the parents, that would be 266 kilometers both ways, and apparently the possibility of multiple deliveries. And you were unaware that your husband was doing this traveling.
Nu cunoșteam.
I was not aware.
And you mentioned that your husband could not provide you with any information about the 3 people who made the transfers to him because he has lost touch with AV, who can no longer be reached through the phone number that your husband had for him, and he can't be found on social networks. Is that correct?
Da, corect.
Okay.
Yes.
And if you didn't know about the funds, is that the reason why they weren't declared on your annual declaration?
Da, sigur acesta a fost.
Yes, certainly that was the reason, because I knew that I had the obligation to declare had I known about that income, about that money, because these are not negligible transfers, and they should have been declared if I knew about them. I knew that's what the law stipulated, but I am as honest as I can be in telling you that I was not aware of these transfers, and I was really dumbfounded when I received the questions of the Commission regarding this matter.
Is there anything else you wish to add or to clarify this issue?
No, there's nothing else for me to add.
I have no further questions.
Anyone else? Yes, Nadezhda, please go ahead.
Mrs. Varlan, I just want to specify whether I got it right. So your husband was not employed since 2011, 2015, right? So he did not contribute with money for the family budget. Did I get it right? Right. No, he never brought any cash money into the family budget. I understood he would work on a daily basis in constructions, right? Yes, it's correct. So whatever he would contribute is like buying food products for your family, right? So you never saw any real money amounts from him? No, I never. Well, now when you phone called him, when you received the questions from the Commission, you asked him about these money transfers. So he made reference to a colleague from the faculty. Have you got any clue? Is there any such person? No, I never known such persons. I never heard about that person. But when you ask the husband, didn't you ask details also about the fact that, well, those old parents, did he communicate eventually anything else? Are you able today to ask for extra details? We are now in a relationship which makes it impossible for me to learn anything else. I was just happy I could at least get these details more specifically. I even asked him to provide the phone number of that person. I would get in touch and talk and ask for the purpose of the transfers, and he said no, he is unable to provide the phone number. He would look for, but he doesn't find it. No social media. So he has a guess that that person is currently in the Russian Federation, but no more details. And he doesn't know whether his parents are still alive? No, he doesn't. Neither is it possible for him because he is also sick, he is unable to travel. Your husband, yes. Thank you.
Yeah, Vitaly, go ahead.
Da.
Doamna Varlan, dar soțul dumneavoastră a lucrat pe știhotare?
Da, au lucrat. Dar a lucrat până anii căsătorii, până în 2010.
We don't get translation.
Yes, he worked, but before we got married. If it's possible, you could once again. He was working abroad until 2010, but we registered our marriage in 2011. In which country? Italy. Thank you a lot. The last topic is also for failure to declare something, and I hope it's going to be a short discussion. Facts. In 2014-2016, you inherited 12 agricultural land plots in Rezina, total surface like 3.5 hectares. You declared all 12 plots in your declaration, submitted to NIA for 2016-2017. In your declaration submitted to NIA for 2018, you did not declare 7 out of 12 plots. In 2019, in the annual declaration, you indicated income of 70,000 lei, and the source is indicated as sale of plots. At the request of the Commission, you provided a copy of the sale purchase agreement, according to which you sold 12 plots of land to a person called VG. In your written responses to the Commission's questions, you explained that you did not declare the 7 plots, probably of a mechanical error. Could you please confirm that in 2014-2016 you inherited 12 agricultural plots? Yes, I confirm. You sold the 12 plots in 2019 for 70,000 lei? Yes, correct. 7 of the land plots are missing from your 2018 declaration submitted to NIA. Were they omitted? Oh, it was an omission, just that. It wasn't done purposefully. When did you realize that you did not declare it? When the Commission started asking questions. Would you like to add anything or clarify? Nothing else. Thank you. Answer accepted.
Anyone else from the colleagues who would like to ask any questions? Okay, that brings us to the end of our questions to you. I would like now to give you the opportunity to make a brief closing statement to the Commission. So please go ahead.
Thank you. I'd like to thank the Commission for your understanding and patience with which you treated me. It was a rather difficult exercise, but at the same time an interesting one. I understood how careful I need to do all the actions, and in the future I'm gonna be very accurate, attentively following whatever is being done, whatever is the action. What I may say confidently is that if any errors, mistakes were identified in my activity, nothing was done with bad will. These were mainly errors, mainly due to lack of knowledge. I would like to state that, last but not the least, I'd like to thank all my close persons, relatives, for their support to move forward, for their support. I am also grateful for my colleagues, for their patience, for being understanding to me in this period of time. And I would like to wish success to the other candidates, and may we all stay healthy, and good luck.
Thank you very much. That brings us to the end of the hearing. I thank you for being here with us this afternoon and answering the questions that we had for you. The Commission will now withdraw for deliberations, and we intend as much as possible to have a decision being decided and transferred to you within a month after the date of this hearing. I hereby declare this hearing closed. Thank you again.
Thank you and have a great day.